The H-1B CAP registration system is officially here. Today is February 3rd, Tuesday, February 3rd, and that is what we're talking about today. My name is Emily Sumner with Sumner Immigration Law. Welcome to Live at Lunch. I'm so glad that you are with us, whether you are joining us live or catching the replay. If you have questions about what we're talking about today, which is the H-1B CAP registration process, or other employment-based and family-based immigration matters, put those questions in the comments. As always, this is not legal advice. I can't give legal advice through this forum, but I'm happy to answer questions and be a help and a resource as much as I can. So let's get started. Recently, USCIS announced the window for H-1B CAP registrations, and that will be from March 4th until March 19th at noon Eastern. So you don't want to wait till the last minute for this. So the selection will be done, the lottery will be done by the end of March, and notifications should come out on or before March 31st. So typically what happens is we register the H-1B registrations, we submit the H-1B registrations, and then usually like March 27th, 28th-ish approximately, we start getting notifications for selections. And of course, we'll have a lot more information on that as the time comes closer. But for right now, what we need to be focused on, we meaning the people who are involved in the H-1B CAP registration process, employers, HR leaders, individuals who are looking to be sponsored for the H-1B, what we need to be focused on right now is preparing for the registration process because it has changed. So there are two major changes for this year for the H-1B CAP registration process. Before I go further, I want to say if you're not sure what the H-1B is or what the H-1B registration process is, we have information about that available on Sumner School Business Immigration Basics, which is the series over on our YouTube channel. So check that out if you want some more basic background information about the H-1B classification. So two major changes this year. The first one is there is no more random lottery, assuming this process stands. So this is a new regulation that recently came out. There is litigation about it. It may be struck down. It may not be. So I know that's not helpful, but we are preparing as if it is going to be in place, the weighted selection process. So in all of these years previously, when USCIS has conducted an H-1B lottery, it's been done totally randomly. So they have not looked at wage levels. They haven't looked at job titles, location. They haven't said, oh, we need a lot of this particular type of occupation, so we're going to select those. None of that. It has just been completely random, and the selection is based on the individual's passport number. This year, the lottery will not be random. Instead, it will be what they're calling a weighted selection process. So the Department of Labor and our webinar from last week, which is available on our YouTube channel as well, our webinar last week went into more detail about the weighted selection process, but basically the Department of Labor has 4 wage levels for every occupational code. If a person, an employer, not a person, but if an employer is filing an H-1B petition for a foreign national, that employer has to attest that they will pay a certain wage, which is called the prevailing wage or the actual wage, whichever is higher. The prevailing wage is set by Department of Labor. And as I said, for every standard occupational code, also called an SOC code, really it should be SOC, but I call it SOC code. For every SOC code, there is a set of 4 wage levels. And that wage, the wage amounts for each one of those levels varies depending on the geographic location. So for example, if an employer wants to sponsor a software developer, as an example, the wage levels that are in the Department of Labor prevailing wage system are going to be different. The amounts, the numerical amounts of the salary for each wage level is going to be different for different locations. So if you're talking about a software developer working in Charlotte, North Carolina, that's going to be different from somebody working in Seattle versus San Diego, Chicago, rural Kansas, wherever it may be. So these wages are set on the geographic location. The geographic location is the area of intended employment, which is a legal term. It's in the regulations, but it means where the foreign national is actually going to be working. So it's not where the company is headquartered. It's not where, if they're working for an end client, it's not necessarily where the end client is located. Instead, it is where the person is actually working. So that's important to know. So the weighted selection process, the regulations say that if a person If an employer registers an employee, or they don't have to be an employee, but if they register a foreign national in the H-1B lottery, they have to indicate what wage level they're going to pay the person. So if a person is entered into the lottery as wage level 4, then that person will receive 4 entries into the lottery. If it's a wage level 3, they'll receive 3 entries, wage level 2, 2 entries, wage level 1, 1 entry. So the idea is that a person who is being paid a higher wage, wage level 4, would have a higher chance of being selected than, for example, an entry level wage level 1. There is a lot of analysis that goes into this, right? So we cannot just, when we enter the registration into the system, the employer can't just say, oh, I'm going to pay them wage level 4. We need to know, and they need to know, the employer needs to know, what is the job title? What is the appropriate standard occupational code? What is the actual salary that you're going to pay the person? Not you're going to say right now you're going to pay wage level 4, and then when you get the H-1B, you're going to pay much less. That cannot be the case. So we need a lot of information just to prepare the registration. And when I say a lot of information, I mean more information than we had previously. So this analysis and this strategy will be done by us as the immigration lawyers preparing the case. Nico has a question, which is a great question. Do we need to mention location and title at the time of registration only? That is an interesting question. So the answer is yes, as far as we know, we do need that information. We are gathering that information from our clients who are being registered into the H-1B lottery system. The reason that we need that is to determine the wage level. So we don't know yet. USCIS has not told us yet. They have not rolled out their interface, what their registration system is going to look like. So we don't know for sure exactly what information USCIS is requiring, but based on the regulation, we know that we're going to have to know that information. We're going to have to know the job title. We as immigration law professionals will want to know the job duties. We will then work with the clients to come up with a strategic plan. So to come up with the appropriate SOC code, that's really important, because if you register as one SOC code and then USCIS later says, oh no, it should have been this other SOC code, your case could be denied. So there's a lot of information that goes into it. So yes, the basic information we are asking from employers about the position is things like the job title, the job duties, the proffered wage, what you are thinking of paying the person, and where the position will be located. And then based on that information, we can guide the employer and help them properly submit the registration based on accurate information and optimized, ideally, for the highest chances of selection. But again, it has to be based on accurate information. So the other big change with that's the weighted selection aspect of the lottery that is happening this year. The other big thing on everybody's mind is the $100,000 fee. That was announced last, I think it was the end of the summer, September-ish, by the Trump administration, that there was going to be a $100,000 fee for H-1B workers. Well, the truth is that it is, yes, the $100,000 fee does apply in certain limited circumstances. However, if you are a foreign national in the United States, or if you are an employer who wants to sponsor somebody who's in the United States, please, please, please have a conversation with us, hopefully, or another qualified immigration lawyer to confirm if that $100,000 fee would apply in your situation or not, because it's entirely possible that it does not apply. It really only applies in limited circumstances, namely, and I'm simplifying here, there are nuances here, but namely, if the foreign national beneficiary is overseas right now, when they're being sponsored for the H-1B, then the $100,000 fee would apply. However, if you have somebody who is, let's say, a foreign national, you want to register in the H-1B lottery, who is in the United States, physically in the United States right now in another classification, for example, they're on F1 working on OPT or STEM OPT, or maybe they're on an L2 working on a work permit, an employment authorization document. If they're here in the United States in a different visa classification, and we ask immigration to change their status from whatever that is to H-1B, the $100,000 fee would not apply, assuming that change of status portion of the filing is approved. So that $100,000 fee only applies in limited circumstances. So don't let that scare you away from potentially sponsoring someone. So let's talk about some frequently asked questions. When should we initiate the H-1B process with your firm? The answer is now. please now. So we have a website, we have a page on our website rather, with all of the information, relevant information. So we have information about the fees, a place to sign the engagement letter. We do, if you are a new client, we do want to talk to you before you sign the engagement letter. We want to make sure that we're a mutual good fit and that it's actually a viable H-1B position before we start going through that process. But lots and lots of resources on that page. I'll drop that link in the comments to this video. But the answer is now. Today is February 3rd. The window opens March 4th. In our practice, we like to, once the window opens, we give it 24 hours. We give it a buffer just so the kinks in the system can be worked out and so that we're not involved in working out those kinks. So we have a 24-hour window buffer, and then we have a buffer of 48 hours at the end of the registration period. We want the registration period closes March 19th. We want to have all of our registrations in by the 17th because we do not want to be submitting information last minute. That's stressful for everyone involved. So, but the answer is now. We want to get that, get everything underway now. So that means if you are a new client, that means reviewing and signing the engagement letter, submitting information, some basic corporate information to us about the company, and then submitting, including the number of employees that you anticipate registering in the lottery. Then we would send you the invoice. We will gather information from you as the employer and from the foreign national about the position, as I mentioned before, so that we can help with that strategic assessment in determining what the appropriate wage level would be. And then we'll get everything registered once the system opens up. Another question that we have a lot is, can we change the position or job or wage level after the candidate is selected? As far as we know, the answer is no. Nobody knows for sure because we don't even have the registration system, the interface available to us yet to know what it looks like. And nobody's gone through this before, but, and there's no guidance that I know of from immigration about this, but I really think that what you submit with the registration is going to be what you're married to, what you're stuck to in terms of the wage level, the job title, the worksite location. That's not to say it couldn't change later, but it does. So for example, if you're working in Mecklenburg County, North Carolina right now, and then you move to wherever, to San Francisco later, then of course you can file an amended petition, but the information has to be accurate as of the time of filing. And you can't change it intermediate, before you file the H-1B petition, probably. What is the latest date that we will accept new clients? We will accept new clients until the registration window opens or until our capacity is filled. Either way, we have space right now to take on new clients, and we are happy to help, but we will not take on new clients once our capacity is filled. We want to make sure that we're able to serve our clients well, communicate well. So once that capacity is filled, we will cut that off. What is the deadline to provide information for review, candidate information for review? We would love all of this information by February 16th, let's say by mid-February, if at all possible, because there are a number of steps that we have to go through internally, and it's a lot of attorney time is involved in the analysis. So we want to make sure that everybody feels comfortable, that we have clear communication, and we have ample time to provide the needed strategy and assessment. All right, and then my final FAQ for you all is, does filing on the first day increase your chances of selection? That's something that people ask every single year. It's a good question, and the answer is no. As long as your registration is properly submitted to USCIS, you have, I was going to say, an equal chance of being selected. Now, with the weighted selection, it depends on the wage level, but there is no benefit to submitting your registration on the very first day of the window being open versus later on in the window. So I hope that you have found this information helpful. Like I said, I will drop the link to our H-1B hub in the comments. If you are an employer looking for assistance, please send us an email. You can email at info@sumnerimmigration.com. If you are an employee and you need assistance and your employer does not have an immigration lawyer that they're working with, we're also happy to assist. Send us an email and we'll get you started on the right path. If you found this information helpful, please share this video with a family member, colleague, or friend, and make sure you're subscribed to this channel with the alert on so you don't miss our next video. My name is Emily Sumner with Sumner Immigration Law. We help clients from around the world and around the United States with employment-based and family-based immigration matters. Until next time.